knew all about our conference and about Asma, and was very proud of the fact that this conference is taking place. And I joined in the prayers for peace and justice in Pakistan and in the world. It's important to approach the topic which I'm introducing in this keynote address this morning, remembering that Australia is a very peculiar country from the point of view of law. Most countries have constitutions that have detailed provisions for the protection of universal human rights. Australia does not have such provisions in its constitution. This is because our constitution is, in the measure of the world, a very old constitution. And at the time it was adopted by the people of Australia at the end of the 19th century, it was not usual to include human rights in constitutions because it was thought that any problems affecting human rights would be dealt with by Parliament. Later experience has shown that Parliament is often the last place where human rights will be dealt with, and that we therefore need to have provisions that protect universal human rights. I'm going to tell you 4 little stories in my available time. The first story is from 1988, so it's 30 years ago. It happened in Bangalore in India, and at that time the Chief Justice of India, Chief Justice P.N. Bhagwati, a great champion of human rights in India, organized a conference on the issue of our session, the use of international human rights law in municipal law, in domestic law. How do we bridge that gap between the universal international law and our domestic law? And present at the conference was Chief Justice Muhammad Hamid of Pakistan. And there were many judges from around the Commonwealth countries. There was one non-Commonwealth judge present, and her name was Ruth Bader Ginsburg, who is now a justice, a very famous justice, still serving on the Supreme Court of the United States of America. And we had a very good conference, like this conference, with many like spirits together, and we agreed on the Bangalore Principles. The Bangalore Principles are very important for the subject of this session. They were signed by Chief Justice Hamid, and by Chief Justice Bhagwati, and by me, and by Judge Ruth Bader Ginsburg. And the Bangalore Principles say this, that if you have a problem as a judge and you have no clear law of your own to apply to the problem, or if the law is ambiguous, then you can fill the gap or resolve the ambiguity by reaching out to international human rights law. That was the Bangalore idea. And that idea was thereafter the subject of a series of conferences held in many countries of the Commonwealth of Nations, designed to try to inform judges about this methodology of using international law for the purpose of filling the gaps and resolving the ambiguities. when I went back to Australia, at that time, I was the president of the Court of Appeal of New South Wales. That is the busiest appeal court in Australia. So I was working every day on appeals. And very soon after I returned, in 1989, this is the second story, I was sitting in court and the lawyers rushed into the court. They had an urgent application. They wanted the court to intervene with an order immediately to a trial judge. Now, if a matter is really urgent, appeal judges will deal with it immediately. And so we suspended the case we were dealing with, and I said, tell us about what the case is. We'll give you 5 minutes to tell about the case. And the case was heard before a very good judge who had been a mentor for me. Very good judge. And it was a compensation case. And a woman was giving evidence, and she was mute. She couldn't speak. And so she had interpretation in what we used to call the deaf and dumb language, signage. And she was giving her evidence and the signage was going on. And the barrister for the insurance company said, I object. And he then said, the objection is this, and there's no need to translate this for the applicant. This is a legal point, Your Honour. And the judge said, yes, Madam Interpreter, you don't have to interpret this for the app. This is a legal point. And the judge went ahead with hearing the legal point, but then he caught on the corner of his eye that the interpreter was still interpreting. And he said, Madam, I've told you, you don't have to interpret. This is a legal point for the lawyers to work out. And the interpreter kept interpreting. And so they went on with the legal point, and the judge saw that the interpretation was still going on. And he said, Madam, I am in charge of the procedures of this court, and I have said that it is not necessary for you to interpret. And the interpreter kept interpreting and said, whilst I am in Your Honour's court, and whilst this court is open, it is both my professional and ethical duty to continue to interpret. And the judge said, I cannot go on with this case if the interpreter is not obeying the directions of the court. And he got up and left the court. So they rushed up to the Court of Appeal and they said, we want an order in the nature of mandamus. I imagine you have a similar order. An order to a public official directing them to fulfill their public duty. And they said, we need to have an order to tell the judge that he has to hear the case and allow the interpretation whilst the court is an open court. And so my two colleagues and I went off the bench and we went into my chambers and we looked up the law on interpretation, and the High Court of Australia, which I later joined, was over us. So we had to see if the court had said anything on this. But as usual, they were no use at all. They said, whether you have an interpreter or not is in the discretion of the trial judge, because the circumstances are always different. And so that didn't resolve our point. And we couldn't find any point right on the issue. But then we looked at the Human Rights Commission Act, which annexed the International Covenant on Civil and Political Rights. And Australia had signed the International Covenant. And we found in there the provision in the International Covenant that if a person is giving evidence in a court and needs an interpreter, they must be provided with an interpreter. And that, we said, means so that they understand what is going on. And so we filed back into court, we gave leave to intervene, we allowed the application, and we directed the judge to proceed and to allow the interpretation to continue.